Good morning, members. We have a quorum. I now call to order the meeting. Welcome. Since the previous meeting, 6 information papers have been issued. Please refer to the agenda for the details. Item 2, items for discussion at the next meeting. You have on your table CB brackets 2 1283 2024-01 list of outstanding items for discussion. The next regular meeting will be held at 4:30 p.m. on the 25th this month. The following topics were suggested by the administration. 1. Reports on the achievements of the Secretary for Justice-led delegation's visits to ASEAN member states. I'm personally very interested in this topic. 2. The latest developments of the judiciary's application of technology, electronic services, and digitization. If there are no objections, these shall be the 2 items in the next meeting. The regular meeting in December will be moved forward to 4:30 p.m. on Monday, 16th of December this year. The one on the 23rd will be moved forward to the 16th. The notice for meeting will be sent out later. If there are no objections, that is decided. Item 3, briefing by the Secretary for Justice and the Director of Administration on the CE's 2024 policy address. We will now invite the government representatives to come in. 3 papers were received. 1 CB brackets 2 1283 2024 brackets 2 paper provided by the DOJ. Second one, paper bracket 03 paper provided by the administration wing of the Chief Secretary for Administration's office. 3 CB brackets 2 1304 01 submission from the Law Society of Hong Kong to the administration on the policy address. You have the other documents, that is the 2024 policy address and the policy address supplement. Members, if you would like to speak, please press the request to speak button. I now first invite Mr. Paul Lam, SJ, to walk us through the paper of the DOJ. Good morning, Chairman and members. Since the delivery of the policy address on the 16th of October, I'm pleased to be here with the core team of the DOJ to brief members on the policy measures in the DOJ's purview. We would like to listen to the AJLSP's views. The policy measures can be summarized into 6 categories. 1. Organizing training for international legal talent. We have launched the establishment of the Hong Kong International Legal Talents Training Academy. We have set up the training office and the expert committee for Hong Kong International Legal Talents Training. It will also double up as the secretariat for the training academy. On next Friday, the 8th of November, we will launch the establishment and also begin to roll out relevant projects so as to provide training for talents for the country involving foreign-related legal affairs, including national law, international law, common law, civil law, national legal systems, and advocacy skills. We will also contribute to the next 10 years of the Belt and Road and contribute our strength to the country so that we can better play our role as a gateway between the country and the world. Second, continue to make every effort to develop Hong Kong into a regional center for international legal and dispute resolution services. On this, there are 3 sub-points. First, IOMED, or the International Organization for Mediation. The DOJ has been working closely with relevant departments to take forward mediation. Now, the convention of the establishment of the IOMED and also the joint statement have been established in October, and it will be signed in next year. We will work with the relevant contractors and the bureaus and departments to strive for the remodeling of the old Wan Chai police station by middle of next year, so that after the signing of the joint statement, the IOMED can be established. It is the first intergovernmental international legal organization dedicated to resolving international disputes through mediation. It is also an important organization for taking forward settling international disputes by peaceful means as stipulated in Charter of the United Nations. It will help Hong Kong to become an international mediation hub. 2. Deepening mediation culture. To enhance the professionalism of mediators in Hong Kong, we will regulate and establish the accreditation system for mediators in Hong Kong. Recommendations will be made by the end of this year. And also to solidify Hong Kong's position as a regional center for international mediation services, we will strive to include mediation clause in government contracts by the first quarter next year, and we will encourage private sector to do the same. We will work with the Civil Service College to provide mediation training for civil servants. In terms of deepening mediation culture, we will roll out the pilot scheme on community mediation, which is a 2-year program to train community workers who will empower the members of the public to use mediation skills in daily disputes. 3. Developing a sports disputes resolution system. Our local athletes consistently achieve well in international sports events. Now, with the vibrant developments in the global sports market, it is important to establish a sports disputes resolution system. To cultivate a vibrant ecosystem of sports disputes in Hong Kong, we will launch the Sports Disputes Resolution Pilot Scheme within the next year to establish a sports disputes resolution system and promote sports arbitration to leverage on our institutional strengths to develop Hong Kong into a sports hub. The third major category is promoting the development of an application of law tech. Now, with the advancements in technology, we need to rise up to the challenges and opportunities brought about by that. In the first quarter next year, we will set up the Consultation Group on Law Tech Development, comprising representatives from the legal and dispute resolution sector, law schools, and law tech solutions providers, to help governments formulate policies and measures on law tech. By sharing their professional knowledge, experience, and insights, the group members can promote the application of law tech in the legal and dispute resolution sector, so as to enhance the efficiency and quality of our legal sector and align with the national strategy of new quality productive forces. 4th, strengthening legal cooperation with the mainland and the GBA. There are 3 subpoints. 1, improving the arrangements for mutual service of judicial documents in civil and commercial proceedings. We will continue to follow up on the conclusion of the improved arrangements for mutual service of judicial documents. The target is that by next year, we will begin to amend the rules of court in consultation with the judiciary within the next year, so as to increase the variety of mutual service means, to allowing Hong Kong invested enterprises to adopt Hong Kong law and allowing Hong Kong invested enterprises to choose for arbitration to be seated in Hong Kong. We will strive to extend the measures to GBA mainland cities and also other pilot free trade zones to strive for better implementation of the arrangement. It will help mainland industries to use Hong Kong as a springboard to go global and also attract global investments to Hong Kong. It will build a more internationalized commercial environment in the GBA. 3, a dedicated platform for GBA lawyers. Now, to promote the professional exchange and training of GBA lawyers, now by next year we will set up a dedicated platform within the next year to address this need. It will promote professional exchange and training and consolidate the professional strengths of GBA lawyers. Also, in the first half of the 2026, we will establish this dedicated platform to facilitate the access to information on GBA lawyers by members of the public and the private sector. The 5th point is to promote the strengths of and opportunities for Hong Kong's legal services on all fronts. Now, besides the four major points I've mentioned above, we will continue to lead local delegations comprising professionals from the legal sector to visit different regions to promote Hong Kong as a leading center for international legal and dispute resolution services. 6. Rule of law education. We attach importance to rule of law education. Now, we have been taking forward this efforts in a multi-pronged approach. Now, we will launch the third phase of the Role Stars Train the Leaders program. Now, through rule of law, through drama project, we will organize large-scale interactive drama activity so that more members of the public can gain a proper understanding of the rule of law through interactive drama performances. Looking forward, we will continue to consolidate our inherent strengths and use our strength to contribute to the country. We will enhance the development of legal and dispute resolution services. We will establish a sports dispute resolution system and use law tech to develop new quality productive forces. And there will be more collaboration in the GBA in the legal fronts. We will take forward the measures expeditiously and also harness support from the private sector and develop the sector further. So that concludes my report. I urge members to support our measures. We will be pleased to answer your questions and listen to your views. Thank you, Chairman and members. Thank you, Mr. Paul Lam. Now, may I invite Mr. Horace, the Director of Administration to brief us. Now, as always, the government will continue to support the work of the judiciary, including taking forward law court construction projects and also take forward measures to use technology in court operations to enhance efficiency. In terms of court facilities, the new district court building at Caroline Hill Road has been progressing well. The target is to complete the construction in late 2026 and commission it in late 2027. The government has also designated the current site of the Queensway government offices and reserved the site of the existing High Court building for in situ construction of a new High Court building. The judiciary has kick-started the initial preparatory work. In terms of use of technology, the judiciary is committed to making greater use of technology for enhancing the efficiency of court operations. It has been proceeding at full steam with the implementation of the Integrated Court Case Management System, or ICMS, promoting remote hearings, live broadcasting, the use of voice-to-text technologies, e-bundles, and so on. The government will continue to support the judiciary's work in terms of using technology in court operations and provide adequate support. Now, the judiciary is working on the court's remote hearing bill, and it will be introduced to LegCo by the end of this year. Now, to further enhance the efficiency of family court operations, in 2023, a bill was passed, and also the adjudicated system has been introduced. Now, the Family Procedure Rules Committee is drafting the relevant rules, and public consultation will be conducted soon. In terms of legal aid, the Legal Aid Department has put in place all enhancement measures to the legal aid system by the end of 2021. The enhancement measures have been effective in forestalling possible over-concentration of cases among certain lawyers, and it strengthened the prevention of abuse of legal aid. It will also widen the pool of lawyers available for taking up legal aid cases and is beneficial to the legal profession in the long run. The Legal Aid Department will continue to rigorously implement the enhancement measures and also step up publicity and explanatory work and take forward public education initiatives. We will review the operation of the legal aid system from time to time to enhance the service. Now, on the other hand, we will continue to conduct regular review on the ordinary legal aid scheme and supplementary legal aid scheme, and also the financial eligibility limits for legal aid applications and Director of Legal Aid's first charge according to Consumer Price Index C. That concludes my report. My team will answer members' questions. Thank you.
Thank you. I now invite Mr. Eugene Yip, Honorary Secretary from the Hong Kong Bar Association, to speak. Chairman S.J., good morning. Regarding the 2024 policy address, we welcome the measures in relation to the legal sector. There are measures to support Hong Kong's status as an regional center for international legal and dispute resolution services. We're looking forward to the signature ceremony of the Convention on the establishment of the IOMET as well as the establishment of IOMET in Hong Kong. We also support the deepening measures in relation to the mediation culture. We are glad to see that the DOJ has already set up the relevant working group. The association believes these measures are helpful to enhance society's awareness of the culture of media first. The association also welcomes the measures proposed by the DOJ to enhance our legal collaboration with the GBA. Regarding to the mutual service of judicial documents in civil and commercial proceedings between mainland and Hong Kong, we welcome this suggestion as well. The efficiency will also be enhanced, and we believe proceedings will be handled more expediently. More efficiently. So we welcome the measures on the judiciary. At the same time, regarding other measures proposed by the DOJ and the CSA's office, we also welcome these measures. Last year and this year, the judiciary is recruiting judges and judicial officers. Many district judges and judges in the CFI continue to be appointed. We have already spoken on this issue. We have talked about the challenges in relation to recruiting JJOs, judges and judicial officers. We think we can review the remuneration of JJOs in order to attract competent legal practitioners to join the judiciary. All along, as usual, the association supports the work of the DOJ as well as the judiciary. Thank you, Mr. Eugene Yip. I now invite Ms. Corinne Wong, Vice President of the Law Society of Hong Kong, to speak. Good morning, Chairman S.J. and representative from the Hong Kong Bar Association. We welcome the measures introduced by the Secretary of Justice. We submitted a submission to the administration regarding our views on various legal policy initiatives. The paper ACB-21304/2024-01. I'm not going to delve into great detail of my submissions, but I'm going to speak on the sports dispute resolution system. The rapid development of the sports industry needs to be backed by the legal sector. Sport disputes are technical matters. They require expertise in order to resolve disputes in this area. Sport law covers a wide area. It shouldn't be overlooked. There are a host of different issues in relation to sports clubs, sponsors, athletes, broadcasting companies, as well as other work that is still emerging from society. All these require legal support. The enhanced status of athletes also leads to broadcasting rights, personal injury action, and so on. Technological developments also mean new contracts are required. With the fast expansion of the sports market, the legal sector has a lot of opportunities in this regard. The Law Society of Hong Kong set up a Sports Law Committee in 2022. It is responsible for promoting the legal services in relation to sports and other areas in order to help the administration to formulate the relevant measures. We have issued a policy statement where we stated our stance, and it is available on the internet, on the website of the Law Society of Hong Kong. We have the 15th National Games of the PRC next year. In February 2025, there will also be an athletes meet for legal practitioners in Hong Kong. There will also be conferences in relation to sports, and there will be representatives from the sports law sector, arbitration sector, members of the public. We will also on a regular basis host the relevant recreational activities in order to achieve synergetic effects. We will work closely with the DOJ and the Bar Association in order to make enhancements to the mechanism on a regular basis. Thank you, Ms. Wong. The floor is now open for questions. First member to speak, Ms. Carmen Kan. Well, how many minutes do we have? 5 minutes each. Thank you, Chairman. Regarding the SJ's report, I have several questions. But I'm going to start with the points that are closest to the hearts of members of the public. October, we have already set up the International Legal Talents Training Academy. It will be commissioned soon. There will be collaboration with other institutions such as the School of Law at the Hong Kong U. They are recruiting maritime law and maritime disputes professors. In some areas in Hong Kong and in China, we also need to enhance our efforts in relation to foreign-related legal affairs. The aim is to build our capacity in this regard. Are there any areas that we can focus on the 8th of November after the establishment of the International Legal Talents Training Office? Do we have any idea of what areas to focus on? I also agree to deepen the mediation culture. The DOJ mentioned in government contracts mediation clauses will be included to set an example for private companies. This is worth recommendation. This is worth commendation. Members of the public may call up 1823 or Office of the Ombudsman to express their views or lodge a complaint. So we shouldn't overlook the contact with members of the public. We also need to step up publicity about the mediation culture. On a corporate level, the DOJ has always been promoting the culture of mediation first. We have already seen results. So it's worth our efforts to deepen the culture of mediation first with members of the public. In relation to allowing Hong Kong invested enterprises to adopt Hong Kong law, it is a line of work to enhance our collaboration with the GBA. Right now, Shenzhen Qianhai is putting in place such arrangements. Will you consider putting in place such arrangements in Shenzhen, for example? 3 questions. We may have the second round. From the DOJ. SJ, please. Thank you, Ms. Carmen Khan. Regarding what areas we are going to focus on in the Hong Kong International Legal Talents Training Academy. It's the 1st of November. Today, Dr. Young assumed office just today, and I'm going to discuss with him later on today. He has a wealth of experience in this regard, and I'd like to tap his views in relation to building our capacity. We want to enhance our capacity in relation to foreign-related legal affairs. For developing countries, they come to Hong Kong to take part in capacity-building programs, and they express keen interest. Locally, we need to enhance our capacity, and we also need to enhance our teaching and learning quality. When it comes to maritime law, I support it. We have our important positioning of the 3 main centers: financial, shipping, and logistics center. We need to dovetail with these 3 centers under our national policies. Maritime law will cement our status as the international shipping center. It has a lot to do with this. Maritime law, maritime insurance, we have our own strengths and experience. Regarding making enhancements in this realm, this is definitely the way forward we'll look into. We'll work actively on it. Regarding deepening the mediation culture, I agree with Ms. Carmen Khan. We don't want to give a misconception to the public that we only promote the mediation culture to enterprises or the commercial sector. In order to help members of the public to resolve their daily disputes, only then can we forge a cohesive community in Hong Kong. We don't just help enterprises or the commercial sector to resolve disputes. We have the Consumer Council as well as other bodies to work on it. We have a suggestion. That is the pilot scheme on community mediation. It won't be simply done by the DOJ. We're going to work with different bureaus and departments. We need to check whether members of the public really have an accurate understanding of the mediation culture. It is also one of our work foci. That's exactly why we have included it in the document. Regarding allowing Hong Kong invested enterprises to adopt Hong Kong law and allowing Hong Kong invested enterprises to choose for arbitration to be seated in Hong Kong. If you are aware, we are going to add more pilot areas under the CEPA Amendment Agreement 2.3. Agreement 2. We'll have to wait for the Central People's Government to make the final decision. After the implementation of this measure, we will make announcements as soon as possible. There will be more pilot areas, but we still have to wait for the Central People's Government to finalize the work plan. Thank you. Regarding maritime law, we need to build a commodity trading center, and maritime plays a very important role. Next member, Ms. Eunice Yong.
Thank you, Chairman. I support the measures to promote rule of law in this year's policy address. In particular, we need to deepen the culture of mediation. Mr. Paul Lam mentioned the pilot scheme on community mediation. I would like to know more about the details of this scheme. We have been advocating this in the community to address disputes between neighbors. In Singapore, they have rolled out community mediation service for more than 10 years. That provides another option besides court litigation. So how will the government train up more community mediators in the 18 districts? We have the JMHO and other mediation organizations which have established in Hong Kong for mediating disputes in marriage, old buildings redevelopments, and so on, and also financial disputes. But we lack a community-wide publicity effort. Now, over the past several years, there were mediation services provided in government departments. That is great. And I would love to see more government contracts with standard mediation clauses in them. The point is we need to train those in the business sector to use mediation as a dispute resolution means. We can train up those in the care teams. You don't have to be a qualified mediator to be able to mediate. So the pilot scheme on community mediation, I hope more people would be included in the program so that they can be trained in their mediation skill sets. On sports dispute resolution, I'm a barrister myself. I've received newsletter from the Bar Association that a study on sports dispute resolution is going to be conducted. So I would like to know the timetable and the manner of this study. Now, in the mainland, there is a sports dispute resolution authority already. So how are we going to approach this? Now, according to the report, there are more than 100 arbitrators and mediators with expertise in sports. So how can they be involved to make the effort smoother? Now, I declare interest. I'm also a family mediator and an arbitrator as well. Now, the point is we need to promote the development of sports culture in Hong Kong and attract international talents here. Now, in the GBA, there's going to be a dedicated law information platform. I'm also a GBA lawyer. I'm also a member of the Lawyers Association of Guangzhou. They also have a platform disseminating information on the latest studies and development of laws. So will there be an app for the use of mainland lawyers and GBA lawyers to understand the developments in the area? Secretary, thank you. On promoting mediation culture in community to address neighborhood disputes. As I mentioned in my answer to Ms. Carmen Can's question, we need to let members of the public know mediation is a convenient means to resolve daily disputes. Now, I'm concerned that whether mediators or community workers have the skill to mediate between community disputes. So that's why we would launch the pilot scheme on community mediation first. The target audience is, say, care team members and also community workers. We would train them to offer mediation to the public in their daily line of work. Not just the DOJ, there are lots of training bodies which will be willing to offer help. So the DOJ will be the coordinator in this. We will match organizations with training capacity with the targeted audience and provide targeted training. Now, in the end, with a better skill set, members of the public would have confidence in mediation, and then there would be a culture in society that mediation is a fair and convenient means to resolve disputes. We will follow that direction. Second, on sports dispute resolution. Ms. Yung asked about the timetable. Now, frankly speaking, we don't have a concrete timetable yet, but there is good reasons. We need to conduct a study because this is not something that the DOJ can handle alone. A lot of stakeholders are involved. It includes other bureaus, for example, the CSTB, the Hong Kong, China Olympic committees and Federation of Sports and so on. Now, since the announcements of this measure, according to media reports, there are different views held by various stakeholders. So first, consultation is necessary in terms of the manner of how we approach it. Of course, in the mainland, they have their own sport disputes authority. In Luzon, Switzerland, they have the world-famous sports disputes authority as well. Sport disputes is different from other forms of arbitration because sports disputes have to be resolved quickly because they are time sensitive. For example, eligibility of athletes to represent the Hong Kong SAR and attend international competition. For example, the issue of sports drug, would that affect the eligibility? So that is time sensitive. The other area is expertise. To be perceived as fair, the mediators and arbitrators must not only be very familiar with the procedures, they need to be credible and reputable in their own sports. So we need a system which is efficient and credible. That's the major goal. In terms of the manners and the formats of this organization, we need to have an in-depth discussion and consensus with stakeholders. As I told the media, mediation is based on consent. At least both parties must accept the concept of resolving disputes through mediation. So we hope that we can have a more in-depth discussion next year. On the third point, maybe we can leave it to the second round because time is up. Sorry, I have been too long-winded. It's fine, Secretary. The answers were important. So I think many stakeholders would like to know the DOJ's position on sports disputes resolution and mediation in community. Thank you. Ms. Maggie Chan. Thank you, Chairman. First, I'm pleased to see that in this year's policy address, the government has taken a more aggressive and more macro perspectives in tackling challenges, but implementation is the key. Now, in terms of the International Legal Talents Training Academy in Hong Kong, now I have no issue with the various disciplines in terms of training, but what about the training capacity? How many lawyers can be trained annually? Now, about legal talents for establishing Hong Kong as an IP, intellectual property trading hub, and also trademarks. Will local lawyers receive more training on trademark and IP products? Now, law tech. Now, in terms of adoption of law tech, last year, the judiciary was not as proactive as this year, so I'm pleased to see the change. Now, small and medium law firms are also included in the use of EBRAM and also law tech. So will the judiciary be part of this effort because the judiciary and the EBRM must work together in offering training. Finally, I'm pleased to see that my recommendation on adoption of law tech and cross-boundary service of court documents were accepted by the judiciary. So I hope there can be more interaction between the DOJ and the judiciary on extending the scope of these arrangements. Secretary, thank you. Concerning the academy and the training capacity. Now, this is not a university. We don't have an enrollment target. Discussions are ongoing. For example, there are mainland organizations we would like to receive training from us on foreign-related law affairs. Now, in terms of the number of trainees, it varies project to project. It is a demand-driven process. We have to consider our capacity, of course, but we are not putting together a major law academy. Every project and every program would be tailor-made to the targeted recipient. So we don't have a targeted enrollment figure, to be honest, but we will be targeted. It very much rides on the discussion results. Second, on IP. Now, the regional IP hub position. That is the purview of the CEDB and the trademark and the IP agency. But we are involved as well. Matching is important. Now, for patent application, do we have sufficient patent agents to support this drive? So we need to have the resources to align with our developments into a regional IP trading hub. Now, this is something we will do in the next week. Now, I have invited Judge Luk to share his experience in the Law Tech Week. Now, Judge Luk is famous for his work in intellectual property cases. So I'm eager to listen to what he's going to say. Now, about application of law tech. I'm grateful for Ms. Maggie Chan's persistent reminders about application of law tech. We have been paying attention to what she said. Now, for large law firms, they have sufficient resources and they don't need support and training from the government as much as small and medium law firms do because they have less resources. Now, through the consultation group, I hope that we can offer more help to small and medium law firms concerning whether members of the judiciary would be involved in the consultation group. That is rather unlikely because the adoption of law tech in court would be up to the judiciary. On the other hand, in the private sector, there has to be an interfacing between the law tech and the law tech adopted by the judiciary. So we will continue to maintain high-level communication with the judiciary and the sector so that the law texts adopted by both sectors can align. But it is not suitable to invite members from the judiciary to join this consultation group. In terms of e-bundle, now the DOJ, the judiciary, and the sector have been working very closely with EBRM to launch the program. Now, I earnestly hope that the enhancement version can be made public by the end of this year.
Mr. Jimmy Ng. Thank you, Chairman. For Hong Kong to become a regional dispute resolution center, the key is promotion. Do we know we have such determination and resolve? Do we know we have IOMAT in Hong Kong? We are part of our country. The country allows us to set up IOMAT in Hong Kong. I believe publicity in mainland China is crucial as well. When I talk to people on the mainland, they don't know Hong Kong will have IOMAT soon. There are many cities in close collaboration with one another along the Belt and Road Initiative and Silk Road. There are also many disputes. I'd like to ask if there is any plan to step up publicity in the cities in mainland China. Can we promote IOMAT so that more people will be aware of the cultivation of the mediation first culture in Hong Kong? As Ms. Corinne Wong said, how many people know what sports law is exactly? I doubt if 10% of the legal practitioners in the legal sector know what sports law is. Will it be commonly used by members of the public? Probably athletes and the sports groups will have to have an understanding of sports law. Otherwise, we won't have customers or clients, so to speak. We need to work proactively on this. Last year, there were 3 mediation offices in society, totaling 1,700 cases. So each mediation office handles 1.55 case on average, and the success rate of mediation is about 60%. That's quite good. There was only 1.55 cases on average every day, so I believe we need to step up publicity. I'd like to know what SJ thinks. SJ, please. Thank you, Chairman. Regarding IOMAT, it's a project on the national level. It's the Ministry of Foreign Affairs that is responsible for it. I visited the Ministry of Foreign Affairs and talked to the principal officials. After the setup of IOMAT, we know very well we need to have people who are going to use the services. Be they public enterprises or state-owned enterprises, we need to step up publicity so that people will feel confident about using our services. So it was one of the main topics of discussion between the Ministry of Foreign Affairs and I. We are discussing the proposals to take it forward, but we'll definitely work hard to promote it. Regarding sports law, Mr. Jimmy Ng is very right. What is sports law? Some countries have a document about sports law, but then it may not be available in other countries. Internal affairs within a sports company may have to do with company law, other may have to do with international disputes or dispute resolution. There are unique features about sports law, but it also has commonalities scattered throughout different realms of law. In this area, while we are researching into arbitration, we will see how we can integrate all these areas, but we'll keep our mind open. When it comes to the number of cases handled by mediation offices, of course, we understand the more the better. Otherwise, we won't promote the culture of mediation first. Many members of the public have heard about the word mediation, but do they know what mediation is exactly? Who can help them? How can we build trust? In Hong Kong, we're so used to the fact that when we fail to resolve disputes, we will turn to lawyers. We need to change this mindset. In addition to stepping up publicity, we also need to change the mindset of members of the public. We need to let members of the public know mediation can indeed help them. They can save money by means of mediation. So we need to let the mediation first culture take root in Hong Kong. The word community is the key. Yes, we will redouble our efforts in this regard. If Mr. Jimmy Ng or other members have more views to offer in relation to promoting mediation first, we're glad to hear your views. Thank you. Next member, Ms. Doreen Kong. Thank you, Chairman. I definitely support the work of the Judiciary. Policy address and the information paper listed a lot of work, and I support it. I also thank the Law Society of Hong Kong for its detailed submissions in relation to the policy address relevant measures. First of all, I'd like to ask about the application of law tech. In the information paper, the SJ mentioned that Judiciary is devoted to applying technologies. AI will be considered for adoption. I know SJ would like to take it forward as well, but can you quicken your pace? Many legal practitioners also said when they went to the law courts in Shenzhen, even judges took part in the research and development in the system. That is an AI system in the law courts. After the rollout of the system, efficiency has been enhanced significantly. After balancing the risks, can we quicken the pace in this regard? Can we model on the AI-assisted court in Shenzhen? I'd also like to ask about e-filing, e-lodgement, and so on. Many legal practitioners want to see its earlier implementation. The procedures are not very clear. Some documents can be submitted by way of e-lodgement. In some cases, this is not available. So both solicitors and barristers understand at the pilot stage this may happen, but they do look forward to practice guidelines or practice directions so that they will have a clear understanding when it comes to what kind of documents can be submitted by way of e-lodgement. If documents can be submitted electronically, will the SJ consider allowing both parties to submit hard copies a few days after the deadline? That is to provide convenience to legal practitioners. For those with legal representatives, is it possible to allow e-copies to replace hard copy? Service posed a great challenge to legal proceedings. For example, cross-boundary proceedings are especially true. It takes quite a lot of time in the service of judicial documents. So is it possible to streamline the procedures? The first question by the SJ, the second question by the Judiciary Administrator. Well, probably two questions have to do with the judiciary as well. Regarding the adoption of the AI-assisted court system in mainland China, it has to do with the judiciary. So let's invite the judiciary to take these two questions. and the SJ may supplement in a moment. Thank you, Chairman. Thank you, Mr. Kong, as well. We have been proactively adopting technologies to enhance our efficiency. As Mr. Kong mentioned just now, when legal representatives submit documents to the court since 2022, we have been implementing the ICMS project, that is the Integrated Court Case Management System. Later on, we will extend the system to the High Court, covering more cases. So cases of more types will accept the electronic submission of documents. In 2026, for litigants with legal representative, it is necessary to submit documents electronically to the court, and this will be a giant leap forward. From 2022 to 2024, the ratio increased significantly to 40% in relation to the adoption of electronic document submission. With the development of the technology, we believe more and more law firms will take part in this project. For unrepresented litigants, there is no timeline to make it compulsory for litigants to use the ICMS. We understand AI provides much convenience, but the application of AI does come with risks as well as restrictions. So in the middle of this year, we wrote out a practice guideline and practice direction in relation to the adoption of AI. It provides that JJOs can adopt AI to help with their work. But we pointed out very clearly that AI cannot replace JJOs or support staff when it comes to their responsibilities to verify the relevant information, to make sure all AI-generated output documents, information are free of error. We need to uphold judicial justice. Going forward, we will research into different technologies to further enhance the efficiency of court proceedings. Thank you. Next, Mr. Dennis Leung. Thank you, Chairman. I also support the policy address of the Chief Executive in relation to the relevant measures. I also thank the DOJ for their work in this area. We have seen great improvements. I'm concerned about the rule of law education aspect. There's a decline in the school-age population. So we need to build an international mediation center and an international legal center. It requires a lot of talents, so we do need to step up publicity at schools. The Law Society of Hong Kong has done a lot in the past. They hold book fairs, and it's somewhat easy to win a prize. I myself also won a prize. I'm concerned about the pilot scheme on mediation in the community. Water leakage in buildings, disputes between owners and tenants, we can put in place pilot schemes to enhance mediation in the community, so more members of the public will recognize mediation as a means to resolve disputes. I'm also concerned about sports disputes resolution. I'm in the middle of such disputes resolution as well. The policy address mentioned for some sports clubs, they're going to have reform. They're keeping it in view. Be they athletes or sports clubs, they also need to enhance their understanding of sports disputes. Many have to do with bribery, as well as money. these sports clubs may also be involved in disputes with National Sports Association. Will a task group be formed within the DOJ to follow up on such disputes? Then we can extend it to the GBA or even the country as a whole. We can devise policies so that the sports disputes resolution can develop well in Hong Kong.
Okay.
Secretary, thank you, Mr. Dennis Leung. I'm very concerned about rule of law education as well, so that's why, since I've come into office, I have established the working group on the Steering Committee on Rule of Law Education and the Road Star program. The point is, we need to enhance the foundation of legal knowledge among the public. Of course, we need more legal talents, but rule of law education is not about training up everyone in Hong Kong to become a lawyer. We want to drive the point that rule of law is very important for society. If that's the case, then more young people would have the enthusiasm to take part in the legal sector and rule of law. Another member mentioned community disputes. I have personal experience of this. Disputes involving nuisance of noise and also renovation would be very costly and would be very awkward if you run into your neighbor in the lift. So that's why I think it is great to launch the pilot scheme on community mediation program. On sports disputes and sports arbitration, we're not just reviewing the dispute resolution part of the equation. There is a chapter in the policy address which mentions that there is going to be a major review on the sports regime in Hong Kong. Now, integrity is the aspiration of the entire society, not just the sports sector. Integrity and corruption-free is one of our major advantages. We are famous for that, so naturally our sports sector should be free of corruption. In terms of promotion of sports disputes resolution, we have to take it step by step. We have to first focus on disputes resolution locally. After establishing brand and the credibility, then we will have the capacity to promote our services in the mainland and overseas. So first of all, we have to deal with issues locally first. Deputy Chairman, Mr. Ambrose Lam. Thank you. Now, according to the SJ, there is much work to be done, and it is not easy to complete each of these tasks. Now, some members mentioned their concern about developing maritime legal services and sports disputes services. Now, you need expertise in handling these cases, and not every lawyer or barrister would like to invest so much time and effort into getting these expertise. We need to train up local lawyers and also make it more convenient for foreign experts in these subjects to come to handle these cases in Hong Kong. Otherwise, the cases would only go to major international law firms to share the pie. So will the government remove obstacles from overseas lawyers handling such cases in Hong Kong and also enhance the training capacity for local lawyers? Over the past years, we have been talking about standardizing and aligning the regulations in the Greater Bay Area. So how are we doing on this front? Secretary, thank you. Concerning sports and maritime law, there is a consensus that we need more talents. On one hand, we will continue to train up the local lawyers. And for existing lawyers and lawyers in practice, they will have to undergo continuing professional developments to adapt themselves to these fields. Also, our future International Legal Talent Training Academy will team up with Scarlett to form a platform to include more elements of maritime law in undergraduate law degree programs. So that's on training. Second, introducing international talents. Now, whether a lawyer is allowed to practice in Hong Kong, the two law associations have much sway in this. They have the responsibility to uphold the standard of professionalism of lawyers in Hong Kong. On the other hand, they will have to ensure that there are sufficient talents in Hong Kong for handling various types of cases. Now, in order that the concern of Mr. Ambrose Lam will not come to exist, that is, cases with no talents to handle. Now, I will communicate with the two law associations to address this issue. Now, about developments of standardized rule in the GBA, we have formulated the action agenda for connectivity in the GBA. Now, that includes alignment of rules and institution. Now, in terms of alignment of institutions, we are going to establish a dedicated platform for legal information in the GBA. In terms of rules alignment, we are going to add more pilot zones for adopting the Hong Kong invested enterprises to adopt Hong Kong law and choose Hong Kong as a seat for arbitration. Now, for talents connectivity, we need to provide a platform for lawyers on both sides to meet up and know each other. Now, if there is a platform for institutional connectivity, it would also help connectivity between talents. So we would follow the action agenda promulgated last year and take the steps towards our goal. We would continue to listen to views from the sector. Secretary, my question is pertaining to rule of law education. I'm pleased to see that the Road Star scheme under the Steering Committee on Rule of Law Education targets the entire community as a whole, so as to enhance the rule of law awareness in Hong Kong. President Xi mentioned that we need to start from a very young age in terms of rule of law education. I agree that you have to start very young to inculcate rule of law awareness among the public. This is the basis for rule of law in society. In primary and secondary school curriculums, however, there is not a comprehensive curriculum on rule of law education. Now, in the second phase of the Road Stars Train the Leaders program, 200 teachers have received rule of law education training. So will that enhance the standard of rule of law education in schools? Now, rule of law education has to be fair, transparent, and so on. Now, the steering committee, the working group on course design and teaching materials, is responsible for the design of the curriculum and teaching materials. So will the teaching materials of teachers in schools concerning rule of law education be provided by this working group? Because you can't just give teachers a free rein on teaching materials design. We have to ensure that the rule of law education is done right in school. Thank you. Rule of law education is something close to my heart. You're right. Rule of law is a kind of value. You have to start early to inculcate this in people's mind. Now, there are hundreds of thousands of children in Hong Kong. How can we be efficient in instilling a sense of rule of law? We have to take it step by step. We have to first enhance the understanding of rule of law among the frontline teachers so that they would not teach the wrong values to the charge. So in the first phase, in the first year of the Role Stars Train the Leaders program, we have been training leaders in uniformed youth groups, for example, the Boy Scouts and so on. Last year, there were more than 100 secondary school teachers who have undergone the training. Now, the number is limited because of the limitation of resources. But after the training program, from what we gathered from sharing sessions, maybe Ms. Carmen Can be my witness. The feedback was very positive. It seems that you have a lot of faith in Ms. Carmen Can. Yes, because she is one of the member in the Role Stars Train the Leaders program. So the feedback was very positive. They even wanted more. Now the challenge for us is how we can rise up to meet the aspiration of the trainees. In terms of teaching materials, I believe the Education Bureau has to step in. Now for our Role Stars program, we have uploaded all the teaching materials onto the website for sharing. The trainees can have free access to these materials. So besides training the rule of law education leaders, these trainees or leaders can also apply these teaching materials in their daily work. The teaching materials were approved by the working group comprising representatives from the legal sector, the academia, and the education sector. Now, these teaching materials are not about the specifics of the law. On the other hand, it is a set of easy-to-understand materials to educate people on the principle and spirits of rule of law. So we have this website. We hope that the teaching materials on the website can help these trainees in their daily work. Now, if resources permit, we will continue to expand our effort. Thank you. Mr. Holden Chow. Thank you, Chairman. My question is about promoting the adoption of legal services in new sectors, for example, shipping and high value-added sectors. Now, the third plenum just confirmed Hong Kong's positioning as a high-end logistics and shipping center. Now, Mr. Ambrose Lam asked questions about how we are promoting maritime and sports laws. Now, in terms of maritime law, we have some talents who are capable in handling these cases, but they are among the few. On this panel, we have had some discussions on how we can promote training for maritime law talents. So I myself have been following on this topic for quite some time. I welcome the upgrading of the Maritime Board to the Maritime and Ports Development Board. Now, with the enhancements to its roles, I believe that it would have a positive effect on the sector. Now, about leasing of ships and also management of ships, of fleets, I believe that there are still some areas uncovered. On one hand, we need to drive the demand for these services. The government has been doing things in this regard. For example, turning Hong Kong into a greenfield bunkering center. And also, in the future, there will be ships calling our ports to engage in trade in metals. So we are driving the demand up. On the other hand, we need to have the sufficient amount of legal talents to handle these services. I agree, not every lawyer is up for this. Mr. Ambrose Lam has said as much. But at least we need to popularize the idea. While you're telling people that we are a shipping hub, you have to also tell people that we have a lot of legal talents capable of rendering maritime law services. So you can tell the world we have a large number of lawyers having received training on maritime legal services. That would bolster our position as a shipping and logistics hub. So that's my view. You have to tell people that we have popularized legal training on maritime legal affairs. We have a lot of experts who understand maritime law, and then after some time, we will see the results.
Thank you, Mr. Hoden Chow. Yes, I agree. This is a chicken or egg question. What are the factors at play when students choose which subject to choose? Will it be helpful to their future? Yes, I indeed agree this is a chicken or egg problem. But at least Hong Kong needs to show others that we have a resolve to do so. Our stance needs to be clear. We need to provide maritime legal courses proactively. At the university level, there are 2 points I'd like to make. We have Scarlet as a type of legal service training. As I mentioned earlier on behalf of the government, I said I'd like to see some areas to be focused on, such as maritime law. For example, the University of Hong Kong works with a couple of different famous universities on mainland China to organize maritime legal courses. I believe universities are working closely with each other. So within the DOJ, we will also encourage the sector to step up efforts in this regard. We need to show others we do have the determination. We do need to make others feel confident in us. That's how we can address the chicken or egg problem. In the interest of time, I need to manage time well. So when members ask questions, please manage your time well. And I will keep the time limit strictly. Next member, Professor Priscilla Leung. Good morning. I'm glad to see the policy address this year. Showing a clear focus on the Hong Kong International Legal Talents Training Academy. We pin high hopes on the training academy. I'd like to respond to the point of maritime legal talent training. I work at the City University of Hong Kong. Mr. C.Y. Leung, while he was in office, set up an office for maritime legal training. The professors left. There weren't enough students either. We need to cement our status as the 3 main international centers. We have already talked to the management of the university. We were asked to raise funds. On the last occasion, I talked to the chief executive myself. Apart from our own efforts, we also need to see whether universities are engaging professors to teach the relevant courses. That is not proactive enough. So we really need to render assistance if we want to promote in this area. When the Secretary for Justice took office, we talked about IP. It's important to attract people to come to Hong Kong to go listed. If we can hold more courses in this area, then there will be more students. IP is different from maritime training, and we do need to step up training, step up publicity rather, in relation to maritime law. In relation to GBA Enterprise Restructuring Center, which is close to the heart to the Guangdong province as well as the Central People's Government, alongside the accountancy sector, legal sector, the economy is not doing well and many enterprises are on the brink of bankruptcy. Let's not call it bankruptcy, let's call it enterprise restructuring. We can provide a one-stop shop to provide services. If we could do so, like Singapore, they are providing high-quality services, then we may attract clients to choose Hong Kong. I commend the pilot scheme on community mediation. My first motion debate was on members of the public who do not have the financial means to institute legal proceedings. I understand mediation courses are very much well received. Many participants come from other sectors, and I believe this pilot scheme can engage practitioners in other fields, other than the legal sector. In relation to IOMED Phase 1 work, we shouldn't popularize the work. We shouldn't allow it to expand to the community at large. We need to keep it at an international level. So once it is rolled out or once it is set up, we need to focus on quality. For the pilot scheme on community mediation, quantity is more important than quality. Next member, Mr. Tang Fei. Thank you, Chairman. I'm also concerned about rule of law education. Promoting rule of law through uniform groups, including their teachers. Yes, this is a very good example. It's a very good way to introduce the rule of law education. Apart from that, we work with the Education Bureau. For a dozen or so uniform groups, they are under the purview of the HYAB instead of the Education Bureau. Not all schools have uniform groups. And even for schools that have uniform groups, they won't have as much as or as many as a dozen uniform groups. 290 participants is mentioned in the information paper. I'd like to know whether the Education Bureau was involved. The Education Bureau may notify schools to take part in such courses. Or can we step up publicity through school councils so that more teachers and students will know about this scheme? The rule of law education has been conducted for a long time. Even during the epidemic, there wasn't any pause to the scheme. So did we step up publicity through principals association, school councils, and so on. Otherwise, if we just rely on uniform groups, that's not quite enough. SJ? Regarding rule of law education, Phase 1, we have conducted it for 2 years. For the first year, we indeed focused on uniform groups. For the second year, we focused on secondary school teachers. The Education Bureau provided coordination, and that's exactly how we had these teachers joining us on the course. So the Education Bureau helped us identify secondary school teachers to take part in the foundation course of the program. Our programs are quite intensive. 2 weekends we have foundation course, we also have advanced course. There are also a wide array of events or activities. So this year, we can only receive 100 or so secondary school teachers, but down the road we'll remain in liaison with the Education Bureau. We know there's a burgeoning demand, outstripping our supply. As I mentioned in the information paper, we visited different secondary and primary schools. We staged drama activities to introduce to students the concepts of rule of law. The results were quite good, despite the rather short time. There were interactions among students. We explained why we need rule of law, why we need fairness. Rule of law education is one element, but we also want to spread the idea of the rule of law education across different schools, be they secondary or primary schools. We did have the help of the Education Bureau, and in the future we look forward to more channels to benefit even more teachers. 4 members have pressed a button to request to speak in the second round. I'll draw a line here. I won't allow any more members to speak in the second round. So these 4 members can ask only one question with a maximum of 2 minutes, questions and answers included. We have another agenda item to go through after this one. 4 members, they are Ms. Carmen Kan, Ms. Eunice Yong, Ms. Maggie Chen, and Ms. Doreen Kong. Ms. Carmen Kan, please. Thank you, Chairman. I'd like to ask about the GBA Legal Information Platform. It is a unified platform. It provides authoritative information to members of the public, to enterprises. This is very important. In paragraph 25, it shows us 480 lawyers have already obtained such qualifications or licenses. How can we get a hold of the relevant organizations in Guangdong so that we can build this platform together? We need to work with the relevant units in mainland China in order to build this platform. We are taking it forward. We need to make sure such information is authoritative. Such preparations are underway. It's quite difficult to foresee the resources, but I do hope more support from the Financial Secretary.
Ms. Eunice Yong, I'm writing on my previous question. A dedicated organization for GBA lawyers is different from that of a dedicated platform. Now there are 24 GBA lawyers, there are 240 lawyers with GBA practicing licenses, but actually 1,000 lawyers have passed the GBA lawyer examination. Why is that so? Now with the dedicated platform, maybe we can better promote GBA practicing license among Hong Kong lawyers. And on the other hand, we can use the platform to introduce Hong Kong lawyers with GBA lawyer practicing license to the residents in the GBA. Now, it can enhance the importance of Hong Kong lawyers in the mainland cities of the GBA. So how will these dedicated platform and the dedicated organization help promote the service of Hong Kong lawyers? Now, about the difference in the figures, after passing the examination, you need to undergo certain training to get the license. For example, I have passed the GBA lawyer examination, but I don't have time to undergo training, so that's why I'm not allowed to practice in the GBA. Now, there are 480 lawyers on the platform. It is a platform for the lawyers to interact and exchange their experience in practicing. So the dedicated platform is an internal one. On the other hand, the information portal is external facing. Now, besides information of GBA lawyers, there is also a page of Q&A to answer queries. So that platform is more for promotional purpose. Ms. Maggie Chan. Thank you. My question is also about that dedicated organization. I declare interest. I'm a GBA practicing lawyer, and I'm the founding chairman of the Hong Kong Small and Medium Law Firms Association. Now, by exchange, do you mean exchange between Hong Kong lawyers with GBA practicing license or lawyers in all 9 cities in the GBA? Just one question, please, Ms. Maggie Chan. Is that related to the first question? So I will rather ask my second question. Now, the Hong Kong Sam Law and another organization have our own platforms for exchange. So will there be a duplication of functions, or would you coordinate the efforts? Secretary, I can answer both questions. Now, when we talk about GBA lawyers, I'm referring to lawyers in Hong Kong and Macau because we are striving to help lawyers in Hong Kong and Macau to practice in the GBA mainland cities. So they are our main targets. Of course, other law organizations have similar associations. But I think this is the only formal platform supported by central authorities for practicing lawyers in the GBA. Mr. Doreen Kong. Now, my question is about legal aid. Now, in the past, abuse of the legal aid system has been a concern among the public. In recent years, there were some personal injury cases with very flimsy justifications. Some unscrupulous lawyers exaggerated the claims or delayed the claims and prevents the cases from being resolved through mediation. Recently, there was a personal injury case with a claim of $5 million. In the end, the court only awarded $200,000 in compensation. Now, these cases have caused the society and insurance companies dearly. So concerning these cases, will the legal aid departments enhance the vetting procedure? May I invite the Director of Legal Aid to answer this question? Thank you, Mr. Ring Kong. Now, concerning abuses, from the start, we would look at the strength of the case very carefully. Even after the granting of approval, we would closely monitor the progress of the case. There are further evidences showing the strength of the case in the process. If we think the case is not strong enough, or if there are problems with the case, then the other party can submit an application for review so that the legal aid department would decide whether we would continue with the approval. Now, over the past year, some 200 cases had their approval revoked by the legal aid department. So with the efforts from all parties, we can prevent abuse of the legal aid system. Thank you, Mr. Chris Chong. That concludes this item. Thank you very much. Next, 2024-5 Judicial Service Pay Adjustment. We have received the paper. That is AW275-010-015-001 concerning 2024-5 Judicial Service Pay Adjustment. And also we have the background brief, CB-2 1283, 2024-04. Members who would like to speak, please press the button. I will first invite Mrs. Millie Ng, Director of Administration, to brief us on the paper. Thank you, Chairman. Today we are briefing members on the 2024-25 Judicial Service Pay Adjustment Recommendation. According to the mechanism, judicial remuneration is determined separately from that of the civil service. It is decided by the Chief Executive Council after considering the recommendations of the Independent Standing Committee on Judicial Salaries and Conditions of Service, or in short, the Judicial Committee. The recommendation will be approved by the Finance Committee. Now, the Judicial Committee will consider a basket of factors and balance the factors. These include responsibility, working conditions, and workload of judges, the overall situation of the Hong Kong economy, public and private sector pay, and so on. Now, the recommended pay adjustment or the pay increase for JJOs would be 3% for 2024 to 2025, with effect from the 1st of April 2024. Now, the Chief Executive Council has accepted the recommendations of the Judicial Committee. And also, about the 3% pay increase for JJOs, the Judiciary has no objections. I urge members to support the recommendation. The recommendation will be submitted to the Finance Committee for scrutiny in due course. Thank you. Ms. Karine Wong, Vice President of the Law Society. Please be brief and keep within 3 minutes. Chairman, members, the Law Society of Hong Kong is aware that there is a shortage of JJOs in Hong Kong. In terms of recruitment, there is much difficulty. It directly or indirectly gives rise to the longer waiting time for court cases at all levels. We are concerned about this. In paragraph 5, it says, as at 31st of March this year, against the establishment of 211 judicial posts, 160 were substantively filled. In other words, 51 vacancies need to be filled. Paragraph 7 says that retirement is the major reasons of wastage for JJOs. In the next 3 years, there will be 5 to 14 JJOs retiring, accounting to 3.1% to 8.8% of the current strength. In view of this, the Law Society has, in the past, made numerous recommendations to the government. In determination of pay adjustment, we need to consider whether the remuneration package is attractive enough for talents to join the judiciary. Now, we need to study how we can enhance the remuneration package and the retirement package as well as the fringe benefits. It will help attract and retain talent. The Law Society of Hong Kong is willing to work with the judiciary to arrange seminars to help our members understand the career path of being a JJO and the remuneration package. Thank you. Now, I will now open the floor. I remind members, if you have any direct or indirect pecuniary interest on the item, please disclose the nature of such interest before you speak according to Rule 83A of the Rules of Procedures. I also refer you to Rule 84 of the ROP concerning voting in matters in which you have direct pecuniary interest with. 5 members have pressed the button. I will keep the time within 3 minutes, questions and answers included. Mr. Tang Fei. Thank you, Chairman. My question is simple, concerning overseas judges. I state my views first. Now, there are some controversies in society on whether we need to have foreign judges. I think we need to have foreign judges in Hong Kong. As mentioned by President Xi, common law system is very important for Hong Kong as an international legal center. Keeping foreign judges in Hong Kong or even extending the number, increasing the number of foreign judges in Hong Kong means a lot. Now, in terms of judicial service pay adjustments, is the mechanism the same for overseas judges? Now, in the education sector, we have the so-called native teachers or expatriate teachers in Hong Kong. Their remuneration package is the same as local teachers, but they have extra allowances to compensate them for coming such a long way to work in Hong Kong. This is for the purpose of retaining these teachers. Of course, it is also controversial. So in terms of judicial service pay adjustments, is there a different system for overseas judges? Director of Administration, please. Mrs. Mi Li. Thank you, Mr. Tang Fei, for your question. For overseas judges, it means judges appointed from common law jurisdiction who are serving as non-permanent judges in Hong Kong. Now, after the appointment, during their service at the Court of Final Appeal, their remuneration packages are based on the monthly salary for permanent judges at the CFA on a pro rata basis, which means if they serve a month in Hong Kong, then they would get a pro rata salary for 1 month. There is no other fringe benefits for them. However, upon arrival, the judiciary would compensate these judges for their air tickets and also local accommodation. Ms. Carmen Kan. Thank you, Chairman. Paragraphs 14 to 16 in the paper, it says that starting from 2005, JJO's pay adjustment has been delinked from that of the civil service. Now, the Judicial Committee noticed that the Chief Executive in Council has approved an across-the-board increase for all civil service payments at the same rate of 3%. So paragraph 15, judicial independence. Because of judicial independence, the Judicial Committee would take into consideration a basket of factors. I also noticed the stance of the Law Society. They are aware of the manpower shortage in courts. So my view is now if the Judiciary Administrator is here, we can have a discussion on how we can adjust the remuneration package to attract more judges. I don't think the Director of Administration alone can answer this question. So the across-the-board 3% increase for civil service has nothing to do with the judicial pay adjustment. Now, in your discussion with the judiciary, what is the focus of the Director of Administration? Now, the recommendation made by the Judicial Committee is 3% increase. Having considered all the factors and the manpower shortage, you consider the 3% increase is reasonable. Why is that? But I really think a lot of questions must be answered by the Judiciary Administrator.
Director of Administration, can you take these questions? The proposal of 3% is set out in the report of the Judicial Committee. It has set out the factors at play. A basket of 12 factors have been considered as detailed in the report. A holistic review was conducted. A few factors have been considered, such as the general economic situation in Hong Kong, the budgetary situation of the government, and the pay situation in the private sector. The Judicial Committee has already considered these factors, and the Judiciary did not object to the proposal either. That's why we have adopted this proposal. Well, on the next occasion, we will also invite the Judiciary Administrator JA to be with us. I have already tasked the Secretariat to invite the JA to be with us so that she could join our discussion on the next occasion. Thank you. Ms. Eunice Yong, I agree to the proposal of 3% increase for judicial service pay. There is the retirement wave, as well as the shortage of judicial manpower. The wages and fringe benefits have not yet catched up with those in the private sector. So the proposal of 3% increase may not be able to help us to address the manpower shortage and retirement wave. After the pandemic and black-clad violence, we have to deal with cases involving national security law as well as non-refoulement claims. These cases are on the rise. Regarding how we can more effectively handle these cases, I understand there are some experienced senior counsel who take some time of their own to serve as JJOs, probably 2 months out of a year. They serve as JJO with the Judiciary. So I'd like to know whether the Judiciary will more actively engage senior counsel to work for the Judiciary. I believe this is a temporary stopgap measure to shorten the wait for cases. This is on a voluntary basis, but can we enlist their help? Is this a factor at play? If we can invite experienced senior counsel, then we can reduce the wait time for court cases. I understand many lawyers are doing so, but do we have any figures? Do we have any indicators? Do we have any directions to enlist the help of senior counsel? If this is going to be a long-term problem without sufficient help from senior counsel, then we will continue to face the issue of case backlog. Some criminal cases are having a wait time of 2 years and even 3 years for civil cases. We need to deal with cases fairly, so I'd like to know whether this will be considered. Well, this should be a question for the JA. So let's see if the admin wing can take this question. Thank you, Chairman. Regarding the proposal of 3% increase, is it enough to attract talents? Well, in the report by the Judicial Committee, apart from the adjustments in the wages, the Judiciary is concerned about retaining experienced JJOs to continue to serve in the Judiciary. They also want to attract well-experienced legal practitioners to join the judiciary. So they are reviewing the wages as well as fringe benefits. The Judicial Committee will positively consider their proposals regarding whether we can engage more senior counsel to serve as deputy judges. Yes, we do agree we need to ease the pressure on manpower crunch. At present, there are 45 deputy JJOs, including 8 judges serving in the judiciary. Let me give you some figures. In the CFI, there are 7 deputy and special deputy judges. In the district court, there are also 7 deputy district judges. As I understand, the judiciary will continue to identify and attract experienced senior counsel to join the judiciary. They have the relevant experience, and they will go a long way towards easing the manpower crunch in the High Court. We do want them to join the judiciary, or even if they cannot join the judiciary right now, we do want them to become deputy judges. Next member, Dr. Junius Ho. This issue has been with us for so long. I agree to 3% increase, even a 30% increase. We need to look at the objective factors and how well the performance is in the sector, be they be they solicitors or barristers. Their salaries are significantly higher than the pay offered by the judiciary. It's indeed a long-standing problem as to how we can attract talents to join the judiciary. I have 4 main recommendations. 1. With the manpower crunch at present, we are 25% short of the manpower. Hong Kong is a community that upholds the rule of law. We have a lofty goal, but then we lack the relevant manpower. It's quite disappointing. We need to support the relevant measures. So what should we do about manpower? We have a total of 13,000 members of the Law Society of Hong Kong. If we can attract 1% of the elites to join the judiciary, that would be 130 members. It's quite easy. We can attract the talents, actually. It all boils down to whether we will do it or not. Regarding solicitor advocates, just the same. There are only 130 solicitor advocates. You may say that lawyers themselves don't make the application, but that's not the case. We need to streamline the measures, streamline the procedures rather. We need to make good use of the help we have at hand. For example, you can contact Ms. Corinne Wong. We need to make good use of the revolving door as well. When a lawyer is appointed as a district court judge, then, upon retirement, the retired judge cannot practice once again. They can only practice in litigation and arbitrations. What about not just working as an arbitrator, also as an arbitration advocate? Speed is key in arbitration. We need to streamline rules. Well, Dr. Junius Ho, please manage your time well. Well, I'm not asking a question. I'm simply offering my views. 10 more seconds for me. The revolving door is quite good. On training for JJOs, many of them are still sleeping, so to speak. I am also working as a lawyer. For a 12-day case, probably there are only 5 court days. What about the remaining days? They've gone to waste. It all depends on the approach of the JJO. Aggressive enough? Ambitious enough? Well, I don't have enough time. Well, maybe the Director of Administration can record it and relay the view to the Judiciary. Next member, Dr. Kennedy Wong. Thank you, Chairman. First of all, I agree with the judicial service pay adjustment regarding the proposal from the administration. When you explain to members of the public or legal or even any member of the public, in accordance with the basic law, we have an independent judiciary. That is the cornerstone of the principle of one country, two systems. We need to continue to cement and enhance our status as an international financial, shipping, and trading center. We have a widely recognized judicial system. We also have the best judges and judicial officers in Hong Kong. They are cream of the crop. They are the infrastructures of Hong Kong. They are the embodiment of soft power we have. When the economy is in the doldrums, when we have a tight budget, the administration will still continue to roll out infrastructure projects, say repair and maintenance of bridges, roads, and so on. From this perspective, judicial service pay adjustment is similar to repair and maintenance. So I think the administration should adopt this perspective of thinking while explaining to the public and the council. In the past, for magistrates' courts, some magistrates were engaged on a contract basis. They weren't engaged or employed on a permanent basis. So does the judicial service pay adjustment have any impact on contract-based magistrates, or does it have impact on permanent magistrates? In the first annex of the report from the Judicial Committee, you can see the salary points on the pay scale for magistrates. Although they do not have any fixed term of appointment or revolving door. In other words, they can return to private practice. Their terms and conditions will also be adjusted, that is upward by 3% depending on their current point on the scale. I will first of all extend the meeting by 5 minutes. Second round, Dr. Junius Ho, and I will draw a line here. Well, Dr. Junius Ho, you still have one more point to mention? Yes, thank you, Chairman. I'll be quick. A few years ago, we made an adjustment to the retirement age of judges and judicial officers. If possible, we can further extend the retirement age for JJOs. We have a longer life expectancy relatively, almost the highest around the world. JJOs have the capability, physical condition, and the wisdom. So if they are capable of continuing to serve in the judiciary, that is something good. The technologies applied in the courts in Hong Kong are quite backward. We need to draw on experience in the mainland. Even overseas jurisdictions pale in comparison in this regard to those in mainland China. I visited all courts in the Guangdong province. What about our judges? Did they engage in any exchange? Well, Director of Administration, I'll reply very briefly. Thank you, Dr. Junius Ho, for your suggestion. The Law Society of Hong Kong in relation to JJO recruitment. There is no ratio carved in stone in relation to barristers to solicitors. They consider all eligible applicants. across different levels of courts. Some 20% of the JJOs are solicitors, whereas 80% are barristers. I thank the Law Society of Hong Kong for the support for our recruitment efforts. We will continue to step up efforts in this area. I will also relate the points mentioned by Dr. Junius Ho to the judiciary. Thank you. Thank you, Director.
Sorry, we have an AOB. Can you give me 10 seconds? Barristers can serve as recorders. What about lawyers or solicitors? Now, according to the law, I think that solicitors can also serve as recorders. Yes, you mentioned the same point that barristers and solicitors should be treated equally. It has been put on record. Members, do you support the government submitting this funding proposal for the scrutiny of the Finance Committee? It is unanimous. That concludes the discussion of this item. AOB, I don't have AOB. Meeting's adjourned. Thank you.